This is a death penalty case. He's a death penalty defendant. It's his decision.
Yes, but it says here the trial court must either conduct an inquiry to determine whether the asserted conflict of interest will impair the defendant's Sixth Amendment right or appoint separate counsel.
But that's his defendant's decision. And the last time you all got almost hysterical that you didn't want me to talk to you about it. You want me to talk to you about it?
But you have not conducted any inquiry. With all due respect,
The inquiry is client.
no.
It's not my job to investigate.
The trial court must either conduct an inquiry.
The latest YNW Melly hearing became highly intense as his attorneys and the judge engaged in a heated exchange over one of Melly's defense lawyers.
I can tell him there's a conflict. There's a conflict, all right? With the same law enforcement agency that the same state attorney's office that's trying to impose a death penalty on him is conducting a criminal investigation against one of his lawyers. So I can save you all that trouble. There obviously is a conflict.
YNW Melly was called into court on Friday for an emergency hearing after his retrial had been repeatedly delayed. First, the prosecution's legal team changed, then Melly sued the Broward County Sheriff's Office over alleged cruel treatment. Now, another major issue has surfaced. One of his attorneys, who appears to be his favorite, could be removed from the case. It's no secret that Melly has a strong preference for his lead attorney, Raven Liberty. Despite facing 2 first-degree murder charges and the death penalty at his first trial, he and Liberty were often seen on camera interacting warmly during court proceedings in the summer of 2023. Fast forward to 2025, and with his retrial approaching, a major complication has emerged. Last month, reports surfaced that Raven Liberty is under investigation by the Broward County Sheriff's Office for alleged witness tampering. While she has not been criminally charged, the investigation's details remain unclear. However, it appears serious enough that the judge directly asked Melly whether he still wanted Liberty on his defense team. The rest of Melly's attorneys have been pushing for more information regarding the investigation, and tensions boiled over during Friday's hearing as they sought clarity on the matter.
This issue, and I agree with you, it's a very important issue, but this is an investigation you all have to conduct in these sessions. You all have to have your time. I don't know who to do.
And of course, we have no ability to investigate secret doings of the state attorney and BSO that we don't have the right to see. So I just wanted to bring to your office attention that there's somewhat of a dilemma here, and that we'll file what we can and see what we can get. But right now we're at a real loss to be able to represent Mr. Dennings the way he needs to be represented.
So Judge, if I may add on to that just briefly, essentially because the one portion of this case that I took on and actually have been lots of money was put into training me on this very issue of these phones, right? So I know what they would have got off of this iPhone. They would have got information regarding my emails. I'm assuming there's further emails warrants to my email accounts. I am concerned, going off what he says, that there's communications between my experts. Almost all my communications are on my emails with my experts' motions, depositions from other cases. So there will be further inquiry to that, and I think we're granted to that. But looking at the court's own order, you had, I forget the name of the case, but the basis was saying that it's been, 14, 15 months at this point. There's no imminent arrest. So I read it as you're finding that there is no criminal investigation, and that was the basis of not letting us have the affidavit. The initial time was.
That's not correct. If this was the statute, they would have been right. I just found that they haven't considered and done anything, and based on the particular procedural posture of this case, whatever it is that they got as a result of this, they got it over a year ago. So if they want to charge you with something or arrest you, they've had a year to do that. I'm not going to sit around and wait for them to make that decision. They obviously haven't made a decision. The statute says if there was an ongoing case, you wouldn't be entitled to anything.
Okay, fair enough, Judge.
I'm just complying with the statute.
May I speak?
Sure.
When we were here the first time on the case, I'm the one that brought it forward the motion, and you asked me what my authority was. I had cited to the court the case of Rutledge versus State, 150 Southern 3rd, 830, 2014. You asked me what my specific authority was, and I said the 6th Amendment and 14th Amendment. I'd like to read from Rutledge, if I might. At the risk of being redundant, we once again emphatically state that when a pretrial disclosure of possible conflict of interest is raised, the trial court must either conduct an inquiry to determine whether the asserted conflict of interest will impair the defendant's Sixth Amendment right or appoint separate counsel. So with all due respect to this court, Your Honor, that's your job, is to find out whether or not there's a conflict for you to do to help in the investigation. We don't have the power. Without the court's help, we'll never know if there's a conflict until possibly it's too late. So you are the person that is supposed to look into the matter for us.
I don't agree with you at all. Your case says Mr. Demons is entitled to be told that there's an ongoing investigation. There is an ongoing investigation. I told him that last time I had a discussion with him directly. After that, Figueroa and Bria completely controlled. This is a death penalty case. He's a death penalty defendant. His decision.
Yes, but it says here the trial court must either conduct an inquiry to determine whether the asserted conflict of interest will impair the defendant's Sixth Amendment right or appoint separate counsel.
But that's Mr. Demons' decision. And the last time you all got me hysterical because you didn't want me to talk to him about it. You want me to talk to him about it?
But you have not conducted any inquiry. With all due respect,
the inquiry is the client.
No.
It's not my job to
The
investigate.
trial court must either conduct an inquiry.
That's with Mr. Demons. That's the inquiry.
Well,
I can tell him there's a conflict. There's a conflict. All right. The same law enforcement agency that the same state attorney's office is trying to impose a death penalty on him is conducting criminal investigations in front of his lawyer. So I can save you all that trouble. They're obviously whether Mr. Demons wants the facility to continue or always continue, that's his decision. But there's nothing else I can do.
So, what resolution is Melly's defense team seeking? They've made it clear. They want the judge to step in.
What is it you want me to do, Mr. Hanson? You want to start deposing witnesses?
Deposing witnesses have
You
inquired.
want me to start deposing witnesses?
I want you to inquire of the state what evidence that they have of a conflict, so we know, in fact, that there's a conflict or not.
The state says there's a conflict too. You
Well,
read their pleading.
they say my client. They say my client's
Hold on,
guilty,
one at
but
a
he's
time.
entitled to a trial first.
They filed a motion that said I'm supposed to remove her. They think I get to decide who's Mr. Demons' lawyer is, not Mr. Demons. I couldn't agree with that. I couldn't disagree with that more. It's his decision.
I believe, as the court, you have an obligation to ferret out what the conflict is so that we can make an informed decision. Right now, we can make no decision. Right now, we can file no motions because we don't know whether we're subject to the conflict at all. Right now, our hands are tied. It's up to the court. You're the gatekeeper for all. I'm imploring the court to find out what the nature of the conflict is so that we can advise our client. Right now, you're just saying to our client, hey, the state says there's a conflict, so you could get rid of your lawyer or keep your lawyer. That's not enough. That's not a Sixth Amendment protections. You want him to make a decision in a vacuum. This is a murder case.
Sir, with all due respect, this isn't a vacuum. He can sit down with Miss Liberty, and you can sit down with Miss Liberty. She's well aware who she's emailed. She's well aware who she's called. She's well aware what's on these records. So talk to your. It's incumbent on you all to fully inform your client. That's not my job. That's your job.
Well,
So tell him what's on there, and then tell him what the conflict is, and he makes a decision. I had this discussion with Mr. Demons. The conflict is, at some point in the proceedings, is Miss Liberty going to make a decision that's not in Mr. Demons' best interest, but it's in her best interest. Okay? You all know what you're doing. I'm not going to do your job. You have to do your job.
No job, Judge. With all due respect, I want you to do your job. And I don't believe the court is. I think the court is shirking its responsibility.
I disagree with you, sir, but you can file whatever appropriate written motion you want. I'll give you a hearing on it, and then you can seek appellate authority to a higher court if you think I've done something wrong.
Thank you.
Will the court at least inquire from the state if the investigation is still ongoing as we sit here
It
today?
is ongoing. They told you that the last time.
It's still,
You said that last time, yeah.
it's still ongoing.
It's still ongoing.
Yes.
And have there been other search warrants and affidavits?
I have no idea, sir, but this is a discussion that you all need to have. I don't have anything to do with this.
We can't discuss if we don't know the nature of the conflict that they're alleging, other than she's under investigation. That doesn't cut it, Judge.
They said, hold on, sir.
I'm
Again,
sorry.
with all due respect, they told you the last time, on the record, it was regarding this case, because I asked them. I said, are you investigating Miss Liberty regarding alleged criminal conduct that has to do with this case, that has to do with Mr. Demons? And they said, yes. So that's what it's about.
Well, then under discovery, for Mr. Demons, they're required to give us that information. anything that is relevant to the guilt or innocence.
Of Mr. Demon.
Yeah, well,
I agree with you.
Okay, and if it's related to the murder case and the tampering case, under 3.220, they gotta give us that
So
information.
file a motion to compel under 3.220.
Okay, we will.
With particularity, tell the state this is what I want. Either they're going to give it to you or not, and if they don't, set it for a hearing
Yes, sir.
on any available date. I'm imploring you all to set these for hearings. That's why I keep giving you dates for all pending motions.
The difficulty is, Your Honor, that since we're on notice of a conflict, a potential conflict, technically we should not be filing any additional motions until that issue is resolved. I think we're bound by the Florida rules of ethics.
Okay. Anything else from the defense today?
No, sir.
Okay.
And while that essentially concluded Melly's hearing, there was still one more matter to address.
Let me, Mr. Ailes, and whoever else wants to answer this. At 1:30 this afternoon, I have to deal with Mariah Hamilton. I have the motions on her behalf. She's going to be present. He's the client entitled to be present. He wants to be, but if he doesn't want to be, he certainly doesn't have to be. He wants to be present. Oh, 1:30. Thank you.
Yep, Melly wanted to attend the hearing for his ex-girlfriend, Mariah Hamilton, who was jailed 2 weeks ago. Mariah plays a crucial role in the prosecution's case. During Melly's first trial, prosecutors claimed that she and Melly spoke on the phone after the murders of Anthony Williams and Christopher Thomas Jr. However, the bigger issue was that Mariah never testified in his first trial, though her mother did.
When you first took the stand, you said, I feel threatened. Who do you feel threatened by? Who? This prosecutor. Thank you.
That happened back in June 2023. Fast forward to 2025. Last month, Mariah was arrested for civil contempt after leaving the country for a birthday trip. I spoke with her attorney, Chris Barris, who explained that there was ongoing confusion about whether a warrant had been issued for her due to her failure to testify in Melly's first trial.
We talked about the possibility that there might be a warrant in existence. The prosecutor had indicated to me one time that there was a warrant. Other law enforcement had indicated to me that there was no warrant that they could find in the warrant system when they checked. So we did talk about that. I did not think it would be a good idea to travel internationally because what happens is when you return to the United States, even before then, immigration, U.S. immigration will check the manifest of an airline for every passenger to determine if there's any warrants or any other holds on it. And I couldn't say either way whether there was a warrant. So my advice was not to travel at all.
Mariah was held in jail for 2 weeks, but this past Friday, she finally appeared before the judge. In a surprising turn, she was placed in the same room as her ex, Melly, someone she hadn't seen or spoken to in a while, according to her attorney. But attorney Chris Barris had a critical question for the judge.
I haven't had some time to speak with Mr. Hamilton. The way I see it, Judge, there's only really one issue here today for the court to decide, and that is whether Ms. Hamilton was legally obligated to appear. The issue is not, whether Ms. Hamilton knew that the police or the prosecutors wanted to talk with her. Those are different issues. We're talking about legal obligation, not maybe moral obligation or some other obligation. My answer to the question is no. She had no legal obligation to appear. Defense has evidence that she was not served. And I hope the court understands I was not Ms. Hamilton's attorney when I believe the former prosecutor filed a motion in order to show cause. I wasn't the attorney back then, so I don't know the events that happened back then. I'm not even sure. I haven't seen show cause order issued by the court. Well, that's another problem, sir, I have. There's,
I don't think that we know directly that she's in custody, but she has actually 2.3 the procedure for security.
well, and I'm not sure. I did see that document. It's the most curious document I have ever seen. A witness coming from outside of the state. What? Again, there's a constitutional issue with that writ or warrant, whatever we call it. No notice, no opportunity to be heard. I don't have any facts that have been, I should say, the state has not presented me any facts that she was ever out of the state. So also, that document, if it is a proper writ or warrant, is stale. That document addresses the trial that happened in 2022, and I believe, I don't have it in front of me, I believe it orders that Ms. Hamilton be arrested and detained for no longer than 60 days during the period of pendency of that trial back in 2022. So it's a stale warrant to begin with. I don't see any legal basis for her to have been arrested or to remain in custody. And you know, in my initial motion, the emergency motion I filed, I did ask ultimately for an ROR. I don't think that's appropriate. I think the court must release her, no conditions. I mean, if the state feels that she's a material witness, I suppose they can serve her with a proper subpoena right now in court or before she leaves custody. I do have evidence. I can give the court evidence, but I believe, you know, it's really the state's burden to show that there was a valid subpoena served upon Ms. Hamilton as the basis for this arrest. Well, thank you, Judge.
What we're doing going forward here, and again, so the record clear, I'm only proceeding in 902.15. When a defendant felt possession on charge for a crime punishable by death or life imprisonment,
Right.
the trial court judge is doing the hearing. That's what we're doing. They require each material witness to enter into a written recognizance to appear at the trial or forfeited some fixed by the trial court judge. Additional security may be required at the discretion of the trial court judge. The state telling the citizens they do intend to. I'm probably inclined to follow the state's recommendations because the other similarly situated which is ROR. Put on pre-trial with the next time not possibly not. They don't think she has to do it. She's still either by the state or by the defendant or any party. She just has to answer to something. So anybody will defy her to somebody. I agree. I don't think we can do the basis. Hold her in custody at this point. Someone shows me something different. But I couldn't find anywhere in the court record where Judge Siegel or Judge Murphy or any judge found her to be directed which is merely a question of non-cooperative material.
Good news for Mariah. She could be released soon.
Just to be clear, this was all taken up with all the documents that these motions are asking for. For counsel, if it was previous counsel, they had all this because it's all in the appellate record. You can pull it all up with the subpoenas and testimony by the state investigator, transcripts, all of that is there that discusses what efforts were taken. And Judge Siegel had that hearing, ruled in favor of the state, it was taken up, and it was denied on the merits.
But I mean, at this point, your objection to proceeding with
No, Your Honor.
Yes, I do. I think the state created this whole problem, and I don't think they should benefit for punishing Ms. Hamilton by requiring a monitor or any kind of restriction on her freedom. And the reason I say that, notwithstanding any appeal that was decided in favor of the state, there was a lie. There was false information regarding the subpoena that was purportedly validly served upon Ms. Hamilton. And I don't think there's a basis for it. Seemed quite unfair to be punishing her by restricting her freedom for something that we haven't even looked at in this hearing.
Well, 902.5 contemplates something happening in the future. They're talking about her being material in trial and they go to the future. There's nothing to do with this.
Yeah, I understand, Judge, but all they have to do is serve her with a proper subpoena right now. She is obligated then to appear or suffer the consequences for failure to appear. That's what I'm asking for. I'm asking just release. Well, no, they didn't. Why do you think that, Judge? Yes, I don't see that they did try.
Well, I don't know. This is the first time law enforcement agencies called me on Sunday at my house to tell me that someone did an international airport for outstanding material witness going on in the trip. Asking me what I would like them to do about it. I don't know anything about it. I've been coming to work in this building for a long time. I know this.
Nor have I. I've been doing this for 30 years. I've never seen this before.
But you got qualified. But at this point, it will be over your objection. I'm not foreclosing you. You want to probably put the written motion. I'll give you an opportunity to have a hearing, an evidentiary hearing, to present anything and everything to you that you would like. With the same opportunity, over evidence and testimony they want. And it could be that I'd agree with you and decide that the monitor is a unreasonable condition. But at this point, over your you're going to follow the state law. And the ROR is not in custody, but she's going to have to sign up a pre-trial. They're going to have to verify her address, and then they're going to put her on an electronic monitor. That's the only restriction. They're not putting any other restrictions on it. She's not charged with any independent crime. When she's serving the subpoena again by any party, she just has to answer the subpoena. So what makes it unique here is that 902.15 allows this procedure only in cases punished by life or the death penalty, and that happens to be the case of doing all cases. We follow the statute. So this works out between ROR, standard pre-trial, and open schedule. There are no other special conditions except to just check in with pre-trial that may not require. I will wait to prosecute that consequence. And the same thing, you got to show up on the occasion for a deposition, or a hearing, or a trial, whether that's the state or whether that's the defense. You just got to answer the subpoena. As soon as this case is done, then this obligation in 902.15 will also be.
But the bad news, she has to wear an ankle monitor.
This here, and we're going to get your address and pre-trial. I'm not going to put your address out on public record right now. What city?
Via, Florida. Yes. So, Judge, is this Hamilton? She's free then at this point?
Well, I think the process out something from pre-trial, we have to talk to her, we get all information, we have to verify her address. So, is it a house or an apartment? Someone else lives inside you? Someone can verify the address there? Okay, so as soon as they talk to your dad and verify the address, then put the ankle monitor. Okay?
So what happens next? Mariah had to sign a written promise to appear at all future court dates and stay in contact with her attorney and prosecutors. As for Melly, he remains behind bars, but is set to return to the courtroom for another hearing next week.
He is set to appear before the judge again on Tuesday, February 18th for another motions hearing. His retrial is a few months away. That's scheduled to begin in September of this year. And as of this recording, Raven Liberty is still listed as one of his attorneys. Reporting for Law and Crime, I'm Elizabeth Melly.